Hello everyone and welcome back to our channel Biodiversity and Conservation. I am Subhalakshmi Raut from Ambika Prasad Research Foundation, India, and we are continuing our UGC NET examination series for environmental science subject. And today we are going to touch the topics of Indian Wildlife Act. So this is fifth part of Unit 8 Environmental Assessment, Management and Legislation. And today we are going to discuss on Chapter 3A, Protection of Specified Plants in the Wildlife Protection Act 1972. So the first section under Chapter 3A is 17A, Prohibition of Picking, Uprooting, etc. of Specified Plant. So here it states that save as otherwise provided in this chapter, no person shall willfully pick, uproot, damage, destroy, acquire or collect any specified plant from any forest land and any area specified by notification by the central government. So we are not allowed to pick or uproot or destroy some of the specified plant from forest. And next it states that no person shall possess, sell, offer for sale, or transfer by way of gift or otherwise, or transport any specified plant, whether alive or dead, or part of or derivative thereof, provided that nothing in this section shall prevent a member of a scheduled tribe, subject to the provisions of Chapter 4, from picking, collecting, or possessing in the district he resides any specified plant or part or derivative thereof from his bona fide personal use. So here nobody is allowed to um, sell or pick or uproot specified plants, but so the exception is given to the members of scheduled tribe. They can pick, collect, and possess these specified plant or their parts in their district, but it should be for their personal use, not for sale purpose or marketing, etc. Now 17B sections about section says about the grants of permit for special purposes. So here the Chief Wildlife Warden may, with the previous permission of the state government, they can grant to any person a permit to pick, uproot, acquire or collect from the forest land or the area specified under section 17A, or transport also, subject to such conditions as may be specified therein, any specified plant for the purpose of. So there are some particular reasons which may be um, allowed for picking or collecting from the forest, which the specified plants, which in normal case should not be allowed to pick up, like for educational purpose, for scientific research purpose, for collection, preservation and display in a herbarium of any scientific institution, or propagation by a person or an institution approved by the central government in this regard. So for these purposes only we are allowed to pick or collect the specified plants from the forest. Now 17C uh, talks about cultivation of specified plants without license prohibited. So it states that no person shall cultivate a specified plant except under and in accordance with a license granted by the Chief Wildlife Warden or any other officer authorized by the state government in this behalf, provided that nothing in this section shall prevent a person who immediately before the commencement of the Wildlife Protection Amendment Act 1991 was cultivating a specified plant from carrying on such cultivation for a period of 6 months from such commencement, or where he has made an application within that period for the grant of a license to him, until the license is granted to him or he is informed in writing that a license cannot be granted to him. So here it states that The specified plants under Schedule 6 are not allowed to cultivate except for some conditions like before the Wildlife Protection Amendment Act 1991. Those who were cultivating the specified plants, they are allowed to keep those plants. And also if 6 months prior from the commencement of the act, they have been cultivating these plants, they are also allowed. And if the person has applied for the grant of license for him to cultivate these plants, then the uh, then the law will decide whether he can keep, or he have to discard these specified plants. So next is, every license granted under this section shall specify the area in which and the conditions, if any, subject to which the licensee shall cultivate a specified plant. So under some conditions they can be allowed to cultivate, who have granted for who have applied for the application for the cultivation of specified plants. So they have to specify the area in which they are going to cultivate these plants, and also about the conditions in which they are cultivating these plants. Now the next one is 17D, that says about dealing in specified plants without license prohibited. So it states that no person shall accept under and in accordance with a license granted by the Chief Wildlife Warden or any other officer authorized by the state government in this behalf, commence or carry on business or occupation as a dealer in a specified plant or part or derivative thereof, and provided that nothing in this section shall prevent a person who immediately before the commencement of the Wildlife Protection Amendment Act 1991 was carrying on such business or occupation from carrying on such business or occupation for a period of 60 days from such commencement, or where he has made an application within that period for the grant of a license to him, until the license is granted to him or he is informed in writing that a license cannot be granted to him. So here it states that, or it says that, no person is actually allowed to deal in specified plants, but if a person has the license from the Chief Wildlife Warden or some other officer from state government, so he or she can carry on their business of dealing in specified plants. But so there are some conditions that applies here, like if before the commencement of this Wildlife Protection Amendment Act he was already doing the business in these specified plants, so he is allowed to continue it, their occupation or business. Or if he or she has applied for the grant of license for dealing in these specified plants, so in writing, you until they are not told to stop the dealing in specified plants, they can do so. And next it states that every license granted under this section shall specify the premises in which and the conditions, if any, subject to which the licensee shall carry on his business. Now next is about declaration of stock. So every person cultivating or dealing in a specified plant or part of the plant or derivative thereof shall, within 30 days from the date of commencement of the Wildlife Protection Amendment Act 1991, declare to the Chief Wildlife Warden or any other officer authorized by the state government in this behalf his stocks of such plants and part or derivative as the case may be on the date of such commencement. So if some people were keeping the specified plants or their parts with them before the commencement of Wildlife Protection Amendment Act. So within 30 days, they have to declare to the chief wildlife warden or any other officer under state government that they have uh, these um, commodities with them or stocks with them, so that they will be safe or immune from punishment. So the provisions of subsections 3 to 8 of section 43, section 45, section 46 and 47 apply in relation to an application and license referred to in section 17C and D, as they apply in relation to the license or business in animals or animal articles. So as there were rules for animal articles, those rules apply for plant articles also, like specified plants also. Now next is the possession etc. of plants by licensee. So no licensee under this chapter shall keep in his control, custody or possession of any specified plant or part or that derivative in respect of which and declaration under the provisions of section 17A(e) has to be made but has not been made, so that it cannot keep those things with them until they have not declared the same to the chief wildlife warden, or any specified plant or part which has not been lawfully acquired under the provisions of this act or any rule or order made thereunder. So without the lawful acquisition, they cannot keep these specified plant or their parts. Next is no licensee under this chapter shall pick, uproot, collect or acquire any specified plant or acquire, receive, keep in his control, custody or possession or sell, offer for sale or transport any specified plant or their parts except in accordance with the conditions subject to which the licensee has been granted and such rules as may be under this act. Now next is 17G section that deals with the purchase of specified plants. So here it states that no person shall purchase, receive or acquire any specified plant or their parts or derivative otherwise than from a licensed dealer, provided that nothing in this section shall apply to any person referred to in section 17B. Now 17H section says about the plants to be government property. So here it states that every specified plant or part or derivative in respect of which any offence against this act or any rule or order made thereunder has been committed shall be the property of the state government, and where such plant or derivative has been collected and or acquired from a sanctuary or national park declared by the central government, such plant or part shall be the property of the central government. So here it states that the plants which are acquired or collected without any permission, so those shall be the property of the state government. And if the plants or their parts have been collected from sanctuary or national park that are declared by the central government, so those plants or their parts will be the property of central government. So the provisions of subsections 2 and 3 of section 39 shall, as far as may be, apply in relation to the specified plant or part, or they apply in relation to wild animals and articles referred to in subsection 1 of that section. So those rules which have been applied for wild animals or their articles, those rules also apply for these specified plants. So this is all from me today. Thank you.